the corporate representative deposition that plaintiff's counsel had served on to be conducted on September 13th, 2022. Defendant timely filed this motion to quash to stay that deposition until the issues with regards to the issues raised by the deposition topics of the deposition for the corporate representative of State Farm. Just the plaintiff has filed a lawsuit related to an accident that happened on April 30th, 2020. Plaintiff has alleged that the co-defendant, Jessica Steinbach, the alleged tortfeasor, was underinsured motorist and has sued State Farm for underinsured motorist benefits under a policy of insurance issued by State Farm. Plaintiff has not asserted any extra contractual claims, such as breach of contract or of good faith and fair dealings, or any other claims under the Texas Insurance Code, et cetera, against State Farm. There is no dispute that plaintiff was covered by an insurance policy issued by State Farm containing underinsured motorist coverage that was enforced in effect at the time of the accident in question. And State Farm has previously admitted, it stipulates that that policy was enforced in effect at the time of the accident. In the event the jury awards amount of damages in excess of the alleged tortfeasor's liability insurance policy limits, then the uninsured motorist coverage would apply in this case, and that's been exhaustively addressed in other cases, such as Brainerd by the Texas Supreme Court. So the only issue that the jury will be asked to decide in this case are the alleged negligence of the alleged tortfeasor, Ms. Steinbach, and what amount of damages plaintiff suffered as a result of the subject accident. In the deposition notice, there's 6 topics. Topics 1 through 3 deal with inquiries into the insurance policy and claims handling process. As such, there's no reasonable basis to depose the State Farm corporate representative about those issues arising from or related to the policy. This case was filed on, the original petition was filed on December 22nd, 2021. State Farm was not brought into this case until April 5th, 2022. State Farm corporate, the adjuster did not receive notice of this, the lawsuit or the claim until the day before April, on or about April 4th of 2022. All actions or information gained related to this case after that time were reasonably in the anticipation of litigation and would be protected work product or privilege. Further, any inquiries to the insurance policy claims handling, and they are overbroad and not reasonably calculated to lead to the discovery of admissible evidence and exceed the scope of the discovery pertaining to the issues on this at this point. Issue number 5 deals with defendant's factual and legal contentions regarding defendant's liability to plaintiff. As you see by my motion, that is ambiguous in that, are they talking about the contract liability?
So there's a Supreme Court, they kind of decision is, it's not in re Allstate. What's the name of the case?
USAA.
Yeah, that kind of determines the scope.
Right.
If I understand it. So why don't we just do a deposition notice with that scope?
There's a recent case out of the Dallas Court of Appeals, the Safeco case, that deals with the issues raised by the USAA case, because the USAA says, certain situations, a corporate representative deposition may be, warranted. However, on relevant grounds. However, there's also our main argument, as in the Safeco case that we cited to in my motion, is on the proportionality grounds, that taking the deposition of the corporate representative who, one, has no personal knowledge of the accident other than by the claims process, which USAA says you can't get into those any issues related to the policy, the claims handling process, things that are work product, which is and privileged. So all the information that State Farm has, we again to in state they give guidance on situations where the discovery may foreclose the need for the corporate representative deposition. Because in the Safeco, in the USAA, the court, basically said that they were the only defendant in that case, whereas in this case, the alleged tortfeasor is also a defendant. So the plaintiff is not being denied the ability to take up the deposition of the opposing party, and State Farm wasn't even involved in the accident and things like that. So they still have the opportunity to depose Ms. Steinbeck if they would decide to do so. Additionally, in USAA case, the USAA all they did because in terms of proportionality, the courts are clear that proportionality acts as a governor to guard against the redundant and disproportionate discovery by giving the court authority to reduce the amount of discovery that may be directed to matters that are otherwise proper subjects under inquiry, but that has to be proved or supported with evidence. In USAA, all they did was produce a copy of the police report. In this case, we have produced on September 19th as a copy of the and date stamped of the unprivileged claim file, which is about 575 pages of the information that's not privileged that State Farm has related to this case regarding the liability and damages issues that will be addressed during a trial on this case. And that's what happened in Safeco. Safeco basically distinguished that case from USAA, and Safeco in that case produced I think about 1,000 pages or so in that case of the unprivileged portions of their claim file. And the court reasoned that the Dallas Court of Appeals reasoned that the production of that information, along with the fact that the USA or the Safeco personnel had no personal knowledge of the case, made the necessity of the corporate rep deposition unproportional, and granted the mandamus on that to grant the motion to quash and prevent the corporate representative deposition in that case. We are arguing that our situation here is akin to the Safeco case and not to the USAA. We've provided and produced more information than USAA, and all the information that, as explained in USAA, we supported our proportionality objections with evidence of basically previously disclosed documents providing the information in its possession regarding liability and damages issues in this case. The Dallas Court of Appeals reasoned that Safeco followed the Supreme Court's guidance in USAA, and we again have produced that in defendant's first supplemental initial disclosures on September 19, 2022. And that correspondence, the documentation of the unprivileged claim file, at 575 pages, included correspondence between plaintiff or his counsel and defendant State Farm, medical records pertaining to the plaintiff that were received from plaintiff's counsel, pictures and other diagrams and maps that we received in a demand letter from plaintiff. And so that is all the information. There's no additional information that would be gleaned from a corporate representative deposition at this point. Because again, the USA.
Okay. All right, let's hear from Mr. Gum.
Thank you, Your Honor. So in distinguishing, as you alluded to, the In re USAA case disposed of the issue as it has to pertain to whether we, as the plaintiff, are entitled to take the corporate representative's deposition. And in that, they did provide guidance as to how a court should look through whether the proportionality requirements are there to allow the corporate representative deposition to continue. And what In re USAA pointed to and allowed in that case is akin to exactly what we've put into our deposition notice. Outside of the couple topics that relate directly with the policy, I will agree that Mr. Gibbs has said the policy was in effect. Here's what the policy limits are, and I agree there may be no need for that, and would be fine with striking that from the notice. What I believe that we as the plaintiffs do have an entitlement to is getting at, and what In re USAA discussed and the Supreme Court of Texas talked about, was that a plaintiff has the rights to question any defendant, including a corporate representative in a first party UIM case, about the facts supporting the insurer's legal theories and defenses, and the claims and defenses from the insured's assertions that are made in the lawsuit. And so just like any defendant in any case, the plaintiff is entitled, before they go to a trial, to inquire of that defendant, what are your defenses? Factually, what do you believe the defenses to be, and why are they applicable in this case? And what do you believe about the plaintiff's own claims asserted in the lawsuit? And so here, although Mr. Gibbs has stated that they've supplemented the claim file, and I won't dispute that it's at our office somewhere. I haven't seen, it just came last week and it hasn't been uploaded, so I don't know exactly what that claim file was made up of. But even with the claim file, we should still be allowed to speak to a corporate representative at State Farm, whether it be the adjuster or otherwise. We have not noticed the specific adjuster. However, State Farm wants to put up a corporate representative to discuss the facts that support our claims and the facts that support their defenses. Because what I anticipate at a trial in this matter is State Farm's counsel is going to argue that there are other reasons why our client, why Mr. Sanders may have been suffering injury, why he may have sought treatment. And those are things that I don't know to this. I don't know what they're pointing to, if there are any other defenses that they're going to point to. And that's exactly what In re USAA says plaintiff's counsel get the chance to inquire about. If you're going to make defenses at trial, then plaintiff's counsel has the right and opportunity to inquire about those defenses and inquire into what are the facts that support those defenses, so that we are educated, as we inquire about settlement negotiations and moving the case forward, what we can expect to be seen at trial. And so I think the In re USAA case disposed of this issue, and I believe we are absolutely entitled to discuss those specific topics with State Farm.
Your Honor, may I reply?
You may.
Okay. Specifically to those factual contentions or legal contentions regarding the plaintiff's injuries and damages, all the information that State Farm, again, has received on that is from the plaintiff. And in that is the medical records regarding his treatment and the things that are in there. Plaintiff has a equal or superior knowledge of his own medical records and pre-accident physical condition, plus any of the State Farm's contentions and bases will be provided in the answer to if there's any pre-existing injuries or failure to mitigate. Those things like that are in the answer, and then a lot of that is derived from the medical records. And then we've also obtained counter affidavit from a Dr. Loudon and other doctors that we've produced and disclosed that information in the reports as a basis for the defenses or contentions related to the damages and injuries or pre-existing injuries or unrelated injuries.
Okay.
And so,
all right. Just a second, Mr. Gibbs. So I'm going to go ahead and order the deposition to take place consistent with In re it's not Safeco, USAA, and with the same parameters that are discussed in that case. So, Mr. Gum, if you can go ahead and prepare an order on that and get that to Mr. Gibbs. At the beginning of the order, it'll need to say, instead of on this day, on September 26, 2022, this material code. I think somebody has a child there. Is that someone's yelling?
Yeah, it's my son.
That's all right.
I'll
That's
mute
all right. It happens. And go ahead and get that to me no later than next Tuesday. Give Mr. Gibbs an opportunity to review it. And anything else we need to cover, guys?
No, thank you, Your Honor.
None from the defense at this time, Your Honor.
All right. You guys have a great day and get that to me no later than next Tuesday, Mr. Gunn.
Would you like that just filed, or is there someone you'd like?
You'll need to
email?
file it and email it to Rhonda.
Okay. Thank you so much, Your Honor.
Thank you, Your Honor.
guys.
Be excused.
You may. Bye.
Thank you.